Hello, everyone. Just waiting a minute here now, just allow people to come in. So we'll be starting very shortly now. So Suzanne, I think we're ready to kick off now. Good morning, everyone. Thank you very much for joining us today for our CPD on the legal structures of service charges, where we're going to be looking at and getting expert advice from Suzanne on both residential and commercial. My name is Neil Flannery. I'm a member support officer here with the Society of Chartered Surveyors. We're joined today here by Suzanne Bainton from Liston & Co Solicitors. Suzanne qualified as a solicitor in 1998. She's worked in Liston Company as a trainee, associate solicitor, and as a partner since 2005. She's a long-standing member of the Conveyancing Committee and a former chair. Suzanne is regularly involved in CPD to the legal profession on conveyancing topics, mainly related to MUDs, and as a contributor to the Complex Conveyancing Manual. During this CPD, Suzanne is going to discuss the legal structures of service charges, including how service charges are usually calculated, what are the usual service charges clauses in residential leases, and what remedies does an owner or tenant have in the event of non-provision of services. Today's CPD will be recorded and the video will be published in the CPD library within the next 48 hours. Please note, if you have any questions at all for Suzanne, please send them via the Q&A feature, and we will leave time towards the end to discuss. So without further ado, please welcome Suzanne.
Neil, thanks very much. Good morning, everybody. I'm just going to turn off my camera because I'd be looking at the slides, so I don't want you to be looking at the side of my face. So I'll just click off the video there. I'm going to talk to you today about, obviously I'm coming from the perspective of somebody in practice as a solicitor, and so it's the legal structures of the service charges that I'm going to talk about, focusing really on the MUD Act in terms of how it affects service charges and how they're calculated and charged out in terms of residential developments and mixed use developments. As I'm sure you all know, the MUD Act doesn't apply to developments that are solely commercial, where you've no residential element at all. And I'll also talk about leases and what's usually in leases, and then touch on debt collection and what tenants or lessees can do in the event the services aren't being provided by the landlord or management company. So I'm first going to talk about what is the applicable law. So if you're dealing with managed development, what law applies depends on whether it is entirely residential, entirely commercial, or whether it's a mixed use scheme. And a mixed use scheme is a scheme where there is an element of commercial and residential. There's a definition actually in the MUD Act. So in the throughout, and I'm sure you're all, I'm going to call the MUD Act, I'm referring, as I'm sure you all know, to the Multi-Unit Developments Act of 2011. We had no law on multi-unit developments prior to that act, and it was recommended by the Law Reform Commission in 2005 that the act be brought in. It didn't come into play until 2011, and it was changed a lot actually through, if you, not that you ever would have the time or inclination, but if you ever did look at the original version of the bill and then the final act, there's a number of changes in it. And that's because there was a lot of engagement between the Department of Justice and the various stakeholders. I'm sure with the SCSI as well, but certainly I know there was engagement with the Law Society and with representative groups of apartment owners who brought to the attention of the department issues with MUDs and how they should be addressed. And the act isn't perfect. I think we've all found over the last number of years there are sections of it that they're very well in theory, but they don't work all that well in practice. But going back then to what's in the Act, there is a definition of a multi-unit development in the MUD Act, and it's a scheme comprising of units where it's intended amenities, facilities and services are to be shared, and there are no less than 5 residential units. So you have to have at least 5 residential units for it to be a MUD. Now I will cover it later on in the slide. The Act does apply where you've less than 5 residential units, but it doesn't come within the definition. And then a mixed use scheme is a multi-unit development of which a commercial unit other than a childcare facility forms part of the development. So if you have an entirely residential development and a creche, that doesn't make it a mixed use development as per the definition in the Act. It's still, it's treated, it's not, sorry, I should start again. It's not, it doesn't come within the definition of a mixed use development. So if you have an entirely residential scheme and the only commercial unit at all is a creche, if any, the MUD Act applies to all of the units. In certain types of developments, those where I mentioned where there's less than 5 units are where you have a development of houses only, only certain provisions apply. Now we're talking today about service charges. So in the context of small schemes where you've less than 5 residential units, all of the provisions relevant to service charges apply. So you don't need to, the provisions of the Act that don't apply to those smaller schemes relate to the transfer of the common areas. And then in relation to house only schemes, again, all the provisions in relation to service charges apply, except there's no obligation to have a sinking fund unless there was a sinking fund already in place as of the date the Act came in, which was the 1st of April 2011, or it's otherwise agreed to have one in place. Now, often in the title deeds, there'll be an obligation on the part of the management company to have a reserve fund or a sinking fund. So there'll be an obligation anyway for there to be a sinking fund. But it's stating the obvious to say that in house only schemes, there's a lesser need for a sinking fund. So there's no statutory obligation to have one. So sorry, just to continue on that in terms of the applicable law. So that's where you've entirely residential scheme other than a creche, all the provisions of the Act apply. If you have a mixed use development, so that's where you have a commercial element in the scheme other than a creche, what the Act says, and this is one of the sections where it applies, it sounds great in theory, but actually applying it can be a different day's work. So the Act applies to all residential units in the development and to commercial units in the development to the extent that amenities, facilities and services are shared by such commercial units and residential units. So in a nice clean case, that would be very easy to apply if you had a spine road down the middle of the development and you had the resi on one side and you had the commercial on the other side. All they would share would be the spine road. And the MUD Act, the provisions of the MUD Act would only apply to that spine road and the budget for that spine road. Life isn't ideal as we know, and in most cases the commercial and the residential are very much intertwined. You could have retail on the ground floor and residential above, or a different mix, but they're often in the same blocks. So arguably you could say, I'm not aware of this ever being, an issue in dispute or ever gone to the courts, but you could argue that if the commercial and the residential units are sharing a block, well then they share, the MUD Act applies to all of those units. But that is what the Act says. It's to the extent that the amenities, facilities and services are shared, that the MUD Act applies to the commercial units. So if you have a mixed use multi-unit development, again, the Act is, you could say, quite vague, because in the, and this probably goes back to the fact that when the bill was originally drafted, it was aimed purely at residential schemes. There was no mention of commercial elements in a scheme. And I know the department had to be advised of the fact that there were a number of schemes where you had a commercial element, and that would have to be addressed in the Act. So rather than being prescriptive, what they did in the legislation was that they said, if you have a mixed use scheme, and going back to what I said, that's where you have a commercial element other than a creche, the provisions of the Act are complied with in relation to commercial units, whereas between different classes of units, sections 18 to 21 are complied with. They're the provisions of the Act that apply to service charges, and a fair and equitable apportionment of the costs and expenses attributable to the different classes of units is applied. Now, different people may have different views on what's fair and equitable, but there's so the Act does give some guidance. It says the reference to fair and equitable means that account is taken of all relevant matters, including the respective level of use of any common areas by the owners of different classes of units and their servants, agents and invitees, and the reference to costs and expenses shall be taken as a reference to the matters referred to in sections 18.3 and 19.1. Sections 18.3, I will go through the various sections, but section 18.3 is where you have your annual budget, and it lists in the MUD Act what has to be covered in that annual budget: insurance, repairs and maintenance, etc. 19 is your sinking fund, and there are 4 categories of expenditure that a sinking fund can be used for. So in a mixed use development, the what you have to do and the way what you have to do in terms of setting up the scheme and actually operating the scheme is that the service charges as between the residential and the commercial have to be fair and equitable, taking into account the respective level of use of the common areas. So that's really the criteria, and that would seem fair enough. Whoever uses the common areas more has to pay more. Now that's you don't have to get into the level of detail of you know, are there 2 people in a unit or 5 people in a unit? It's probably fair to say based on a higher size, there's going to be more use of the common areas. But every scheme is different, every mix of unit type is different, and there just needs, if you're involved in a scheme that's been set up at the very beginning, that's the criteria. If it's a scheme that's up and running, and there's a perception from one class of unit owner that the service charges aren't fair and equitable, I will talk about later how you can go about changing the lease if you want to. But if the management company isn't willing to change the apportionment or can't change the apportionment, then the disgruntled owner who's not happy with how it is apportioned does have a remedy under the MUD Act to apply to the Circuit Court to have it changed. I will talk about that later on, but that's the requirement of the Act, has to be fair and equitable based on level of use of the common areas. So I'm going to talk now about the relevant provisions of the MUD Act that are relevant to service charges. So these are sections 18 to 21 of the Act. And just to recap, these provisions apply where you have a fully residential scheme or you have a mixed use scheme where the commercial units share the facilities with the residential, and insofar as they share the facilities, these service charge provisions apply. So section 18 requires the following. There's a number of bullet points here. Section 18 is quite a long section. There was a perception, the whole idea of section 18 was because prior to the Act coming in, one of the issues that I was going to say apartment owners, but owners, it was mainly apartment owners, but people living in multi-unit developments, one of the main issues they had with service charges was that there was no transparency. They basically got a bill every year. They were told this is how much you have to pay. It doesn't matter what level of services they were receiving. They were lucky if there was an AGM where they were given. Now I'm being I'm just, you know, I'm saying it to stereotype. Not every management company worked like this. But there wasn't a good, especially when developers were still in control of the management companies. Some of them weren't great at having their annual AGM, at producing annual accounts for owners. And so there was no, you know, owners just had to pay and that was it. And they didn't have any, you know, there was no democracy or, you know, transparency in relation to how the service charges were calculated. So the idea of Section 18 was to address that. Also, one of the main purposes of it was to address the fact that particularly developer owners, where there wasn't a lease for the unit, had no obligation to pay service charges. Because prior to the Mud Act, if you were suing somebody for service charges, the only way you could sue them was on foot of the lease. I know we had a few cases prior to the Mud Act where you were looking at quantum merit, which is, you know, you're really kind of not quite clutching at straws, but it's a difficult argument to make. So, but where you didn't have a lease, which was typically where the developer owned the unit, you had no basis to sue for the service charge. So that was one of the main reasons for purposes of Section 18 as well. So, drilling down into the detail of it, what it requires is a scheme to be put in place in respect of annual service charges. Now, one of the, and I'm sure many of you will be familiar with answering the pre-contract requisitions for multi-unit developments, and one of them asks about the scheme, and the answer is usually see title deeds and budget. So the scheme is usually set out in the title deeds, but if there is no scheme in place, then a scheme has to be set up by the management company. I had a case recently where one of the queries raised by another solicitor was that there was no scheme. The lease, unfortunately, isn't ideal. It's it's an older lease. So whilst it's not the best scheme in the world in terms of how the service charges are calculated, it is the scheme for the development. The second bullet point there, service charges cannot be levied unless they've been considered by a general meeting of the OMC, the owner's management company, such meeting to take place within reasonable proximity of the development and at a reasonable time. Now, we've all come across people who have, you know, they can split hairs in terms of different issues, but what is a reasonable time? That can be subjective in terms of what one person thinks is a reasonable time may not accord with somebody else's view, but that is the requirement of the Act. So that's all. That change was aimed at ensuring that owners were invited to a meeting. It's often the same meeting at the AGM. It doesn't have to be. It just has to be a general meeting. It's sometimes called, as I'm sure you know, a budget meeting, and it can form part of the AGM or can be held separately, but you cannot levy a service charge unless it's been considered by a general meeting. I had a lot of queries back when, you know, COVID first hit in terms, and there was delays for management companies in having budget meetings and AGMs, whether they could actually bill out their service charges. Now, according to the letter of the law, you cannot levy a service charge before you have that meeting. You could certainly ask owners to pay, and if they volunteer to pay, that's absolutely fine, but you couldn't sue them on foot of the service charge until the meeting had been held. And I have had a number of cases. It's not ideal, but you can, you know, retrospectively approve a budget as well. There's nothing in the Act that prohibits that. The service charge estimate, the Act talks about estimate, I suppose, certainly I would usually refer to it as a budget. It has to be broken down into the categories listed. So if you were preparing a budget, you may want to look at Section 18(3) of the Act, and it lists all the headings that have to be included. and these are the annual recurring expenses. And the first two are insurance, general maintenance, and there's a list in section 18. So it has to break it all down. Now you're not limited, excuse me, to that list, but those items need to be included. At the meeting, when the budget is presented, it can be amended once 60% of those present and voting are in agreement with the change. I've seen that happen myself in the case of maybe landscaping. People have different views as to whether more or less should be spent on landscaping. So, you know, somebody in the meeting could put forward a proposal that the amount to be spent on landscaping would be reduced. And then if at least 60% of those present and voting agree to the change, it can be changed in the meeting without having to come back and have another meeting. For the budget to be approved, it's a very low threshold. It's 25%. Now, the Act talks in the negative. It can't be disapproved. What it says in the Act is that if it's disapproved by 75% or more, then you revert to the previous year's budget. So what that means in practical terms is that more than 25% of those present and voting must vote in favour of adoption of the budget. Now, I have seen it is important. Again, we've all come across those people who are very much in favour of holding management companies to account. There's nothing wrong with that, but they can, you know, hold them to account in terms of the absolute requirements of the Act. So there has to be a vote on the budget. It can't just be proposed and seconded. There has to be a vote, and there at least more than 25% of those present and voting have to vote in favour of its adoption. If it's not approved, the budget for the previous year continues to apply. And if there was no service charge in the previous year, the directors may determine a scheme to apply for 4 months. Now, I was trying to think where you'd have a circumstance that there was no service charge in the previous year, other than in relation to a new scheme. And there's another section of the Act that deals with the new scheme where rather than there, but where no units have yet been sold, the OMC can set the annual service charge without holding a meeting. So before you sell a unit, the directors who are usually the developer nominees, they can set an annual service charge without the need for a meeting. But once you come into the next year and there's units have been sold, there has to be a meeting before the service charges can be levied. And under section 18, service charges cannot be used on matters the responsibility of the developer or builder unless approved in writing by 75% of the members. Now, it's not 75% of the members present and voting, it's 75% of the members. And for such approval to have effect, at least 65% of the units must be sold to third parties, not to developers or their associates, and the common areas transferred at least 3 years prior. Now, that query comes up a fair bit in terms of levies. So a number of apartment schemes have issues unfortunately, with fire safety issues, and levies are necessary to address them. And such levies are usually, well, certainly if I'm advising a management company, they're levied under section 19, not under section 18, because section 19 relates to sinking fund expenditure, non-recurring maintenance, improvement of the building. Excuse me. One of the reasons you would not be able, I think, to put it in under section 18 is, one, because it's not a recurring expense, and two, because it would be difficult, if not impossible, to get 75% of the members to approve in writing, to approve of the levy in writing. Even if you could get that, you'd have to have your common areas transferred more than 3 years prior, and at least 65% of the units must be sold to third parties. So if there's an issue of annual repair and maintenance, then that's something to which this provision would apply. But if it's a once-off cost, then it would generally fall under section 19 and that restriction wouldn't apply. Now, I don't have a, you could say, well, why does that restriction apply to section 18 expenditure, the annual recurring expenditure, and it doesn't apply to section 19? I don't know. That's just the way the Act is drafted. But it would have caused management companies a huge amount of difficulty who were under, a lot of pressure from either the fire officer and or their insurers to do works if they had to comply with this requirement of the 75% approval in writing, and indeed having the common areas transferred, because that's not always, it's not ever within the control of the management company. It's something the developer has to do. So I've never had a case where a management company was looking to get that approval in writing, but if it is given, the OMC can recover such expenditure from any person responsible. Now, usually in the case of levies for developer defects, the developer will have been asked to, address the defects and called upon to compensate the management company for the costs. So that would cover the management company in terms of recovering the costs. But if you were levying the costs under this particular section, the Act allows you to recover them from the person responsible. And each owner has a statutory obligation to pay service charges levied under section 18, including the developer or building contractor. So that's to do with voids where you have units owned by the developer, or indeed the building contractor is mentioned there. Even where there's no lease, there's an obligation to pay service charges. So certainly our practice, and I'm sure the practice of legal firms who do debt collection work for management companies, when you're suing for service charges, is to rely on the lease, but also to rely on the statutory obligation under the MUD Act to pay the service charges. That first bullet point should say nothing rather than noting, but nothing in the section prevents an owner from seeking and recovering reimbursement from a tenant. Now, I'm not sure why the Act had to say that, but maybe just to make clear that even though an owner has the statutory obligation to pay service charges, there's nothing to stop an owner from agreeing with the tenant in the lease that the tenant is to pay the service charge. The annual service charge is to be calculated on a transparent basis and equitably apportioned between unit owners. So it has to be clear how the service charge has been worked out, and it also has to be equitably apportioned between unit owners. I've had many cases over the years where I've been asked, is this equitable? This is where the ink is well dry on the lease. But its operation isn't seen to be equitable. One obvious example we had was a number of years ago where there was a commercial unit on the ground floor, an insurance loading because of the particular use for that commercial unit. And so the block insurance was higher, but the lease for the commercial unit didn't oblige them to pay any increased loading, and so the apartment owners were, basically sharing the cost of this loading, and we got council's opinion as to whether, it was worth going to the court to seek to have the provisions changed. And certainly the view of the barrister was that it could be, it could be difficult. The client, it was entirely possible, but there was no guaranteed outcome. So in that case, the client decided not to proceed. In setting the service charge, the OMC must have referenced the actual or projected expenditure for the relevant year. Now that sounds like we're stating the obvious, but in setting the budget, you have to look at what has been incurred either in the previous year or what it's likely the management company is going to have to spend money on for the next year. To the extent an excess is collected, this is to be taken account of in setting the charge for the following year. So if you overestimate how much you need for your landscaping and you don't spend it all, then in next year's you should take that into account. And to the extent the amount collected is inadequate, the relevant amount can be added to the service charge for the following year. So that's the opposite of the provision above. And an OMC is obliged to keep sufficient and proper records of expenditure to allow appropriate verification and audits. This is all aimed at that transparency, that owners know what they're being charged for, how their share of the costs are calculated, and that all these provisions are aimed, at achieving that. So that's section 18. And at the risk of repeating myself, these provisions that I'm going through, they apply to schemes where you have all residential, or they apply to mixed use schemes where the units share services. So section 19, that's the sinking fund. This requires the following. Again, the purpose of this section was to address the fact that a lot of management companies didn't have a sinking fund or had an inadequate sinking fund, and it was the experience of a lot of unit owners that when there then was a big expense to be incurred, they were being obliged to pay levies. So to address that, the whole purpose of section 19 is to address that. So it obliges an owner's management company to establish a sinking fund, and there are 4 categories of expenditure. There's refurbishment, there's improvement, there's maintenance of a non-recurring nature, or there's advice from a suitably qualified person relating to paragraphs A to C. Now, I have, over the years, I've been asked, is it sinking fund expenditure, or is it the annual sinking fund, particularly in the context of maintenance of a non-recurring nature, because that requires certification by the board and by the members, which I'll come to. It can be difficult, if you look at it, if you look at refurbishment, if you're talking about, replacing the carpets, is that repair and maintenance, or is it refurbishment? The fire safety issues that I mentioned, is that the improvement, of a development? Maintenance of a non-recurring nature, I'm not sure there's any maintenance in a MUD that wouldn't be recurring at some stage, because even if you're replacing the lift, you're replacing the electronic gate, you're replacing the roof, whilst they don't recur every year, they do recur every 10, 15, 20 years, whatever it is. So the wording of the Act, I know what they intended to do, but when you actually go to put it into practice, it sometimes isn't as easy. And as I say, the category that causes some difficulties is maintenance of a non-recurring nature. And what that means is that it relates to a matter in respect of which expenditure is not generally incurred in each year. So that addresses the problem of the lift being needed to be replaced every 15 or 20 years. It's non-recurring if it doesn't happen every year, or it doesn't generally happen every year. It also has to be certified by the directors as being expenditure on maintenance of a non-recurring nature. And it's the third limb that can cause difficulties in practice. The expenditure is approved by a meeting of the members as expenditure of a non-recurring nature. So say if your lift breaks down, the contractor says can't be fixed, we have to replace it. Do you have to go to the members and get approval? Now, it would depend on the circumstances of the case. I'm not going to give you a black and white answer to that, but it's on a practical basis almost impossible for a management company to go to members and look for approval where you have an unexpected item of expenditure. You have the same provision there. Each owner of a unit, including the developer or building contractor, is obliged to make a payment. So there's a statutory obligation to pay. And the amount of the contribution is €200 or such other amount as may be agreed by a meeting of the members. I have been asked very, very many times, is the sinking fund to be paid? Is it the same amount per unit, or is it to be apportioned as per the lease? I think the answer to that question is, under the MUD Act, the clear intention, when you look at, I've to answer the questions that management companies have asked me, I've gone back to the Dáil debates, and clearly the intention, I'm not sure that's what the Act says, but clearly the intention was that it would be the same amount per unit. So whether you were in the penthouse or you're in a one bed, you paid the same amount. But that's not exactly what the Act says. Also under your lease, because owners now, they've an obligation, they've a statutory obligation to pay the service charge and sinking fund contribution under the Act, but they also have their lease, and the lease will apportion the costs, including the sinking fund costs, as per the apportionment. Usually it's very unlikely to be equal unless all the unit sizes are the same. So that can be an issue of contention and discussion, particularly where there are large levies involved. There's an obligation to set up a sinking fund no later than 3 years from the date of the first sale, or 18 months from April 11. The 18 months has since expired. So if you're involved in a new scheme, the obligation to set up the sinking fund is within 3 years of the first sale. Sinking fund contributions are to be held in a separate account and in a manner which identifies the funds as belonging to the sinking fund. I know, again, these people who split the hairs, and they can say, I know a lot of management companies will transfer funds to the sinking fund at the end of the year, and owners might say, well, no, if I pay my service charge and my sinking fund contribution is to go into a separate bank account. Not always just practically possible. Not everybody pays at the beginning of the year. The sinking fund can only be used on the expenditure referred to above. So it is important for a management company, when they're using money from the sinking fund, to think, is it improvement, is it refurbishment, is it maintenance of a non-recurring nature, or is it payment to a surveyor or a solicitor or whoever it is in connection with those items. And if there is a dispute, it can go to the court to be determined under Section 24, bit of a sledgehammer to crack a nut. But if you had a dispute as to whether, for example, if you dispute about expenditure that somebody was saying was the responsibility of the developer, should fall under Section 18 and needed that 75% approval. If there was a dispute about that, it can be referred to court. The other 3 sections of the MUD Act that deal with service charges and sinking funds, there's Section 20 that deals with house only developments. I touched on that. You don't have to have a sinking fund for a house only development unless there was already one, or there's an agreement, and there often is an agreement in the title deeds. Second, now the level of the sinking fund obviously has to be appropriate to the scheme. So there's no prescribed level of a sinking fund. It could be fairly low for a house only scheme. Section 21. An OMC can issue a single request for payment of the charges under Section 18 and 19. So the service charge demand can deal with both limbs, has to set out the basis of the calculation of the charge, the service charge, and the sinking fund contribution, a breakdown of how it is calculated, that should say, sorry, I thought I corrected that, a breakdown of how it is calculated and the amount payable in respect of the unit concerned. So that has to be on the request for payment. And then Section 22, there was talk about service charges going to the small claims court. It didn't happen. They can be collected separately and they can be recovered as a simple contract debt in a court of competent jurisdiction if the debt is up to €15,000, which is normally the level you're dealing with in debt collection. It's the district court. Otherwise, it's up to the circuit court. And if it's over 75,000, I've never had one of them, it's the High Court. So in terms of residential leases and what are the usual provisions, since the MUD Act came in, the common areas have to be transferred from the very beginning. So you don't have this nonsense, if I can use that word, where the developer was to provide the services and collect the money until transferred to the management company. It's now from the get-go, the management company and the owners, and that's reflected in the title deeds. There'll be a separate covenant in the lease, how the service charge is to be paid and the relevant contributions and what are the budgets are in the lease. And I'm going to be talking from now until the end really about the lease. You're subject to those provisions of the MUD Act that I referenced. When you're looking at service charge collection, you're always going back to the lease, both in residential and commercial. So in residential, the proportion is usually set by reference to floor area or the size of the unit. Each owner has to pay a sum in advance on an account. That's your budget, and you pay as per the budget up front. And the lease usually provides that the sum is the amount that the OMC shall, in its sole discretion, deem to be a fair and reasonable payment. But that obligation is subject to Section 18. So you have to have your budget meeting, you have to have your budget approved before you can levy a service charge, irrespective of what the lease says. And then at the end of the financial year, I had an agent say to me recently, oh, in residential, you don't have to do the accounting and pay back the owner if there's an over collection. And I said, well, no, the lease says you do. So what the leases all say or generally say is that at the end of the year, the OMC is obliged to provide a certificate of the amount of charges incurred for the previous year, and each owner is entitled to that certificate on request. The lease just normally says on request. Now that's normally an auditor's certificate of what expenditure has been incurred in the previous year. An owner can request that, but they're not generally provided routinely. They may well be provided in a commercial setting on a routine basis. And then what the deeds usually provide is that after that end of year certificate, an account of the service charge is to be given with any credits for an overpayment or with the owner being liable for any undercharge. Now in practice, what management companies usually do, if there is an excess, it's carried over to the sinking fund. It's not refunded to members, but it could be given as a credit to them in their service charge accounts if there's a big, if there was a big over collection. A well-drafted lease will allow the OMC to vary the service charge apportionments once they act reasonably and in the interest of good estate management. Older style leases will generally not allow it unless there's a change in the number of units, but more modern leases will allow the management company to vary it. A lease usually provides that an owner is to pay interest on overdue service charges. Now, the method of calculation, as I'm sure you know, a lot of leases will refer to the AAA rate charged by AIB. I'm not aware there isn't a AAA rate, or will say R 8% or 15%. Now, those rates tend to be penal rates of interest. If I'm working on a new scheme, what I'd like to see put in is that the rate of interest is the same that has to be paid on overdue income tax. But the courts, there is case law on this, not to do with service charges, but the courts won't enforce penal rates of interest. So that is something to consider in debt collection proceedings, and in maybe, coming to an arrangement with an owner who's in arrears, that the management company may be willing to, do something on the interest. In many unit deeds, and this would apply to residential and commercial, the easements granted to owners, such as a right to park, a right of access over the common areas, are conditional on the payment of service charges. So, I'm often asked, can we withdraw the fob for the car park? Can we change the locks on the front door to the block and not give it to debtors? Or can we turn off the water? Now, I generally wouldn't advise about turning off the water or refusing access to owners, because often there are tenants or other residents in occupation and they're totally innocent. They haven't done anything wrong, and it certainly shouldn't be done without, a lengthy period of notice being given, excuse me, to both the owner and the occupiers. But car parking facilities is something that can quite often be withdrawn, but you have to look at the lease and you have to check, does the owner own the car park space? Does the owner have a license to use the car park space? Is the right to use the car park space conditional on payment of service charges? if the owner owns the car park space and there's no, there's no conditionality in the lease, the management company could be, trespassing if they go and, clamp the car. And also the obligations to provide services are subject to compliance by the owner of his or her obligations, including the obligation to pay service charges. So the obligation to, give you a fob for the front door, to process an insurance claim, they're ones that will come up in practice. The management company has no obligation to provide services unless an owner has paid. So what documentation is an owner entitled to? So in a residential scheme, what an owner will get, and this often is replicated in commercial, the annual budget, which has to be approved at a general meeting. So the budget goes out with the notice of the meeting. It's 21 days. The service charge demand, it has to set out how the service charge is calculated, the basis of it, and both in relation to the service charge and the sinking fund contribution. The auditor's certificate, if requested, so that's the certificate of expenditure for the previous year, and an account of service charges following the issue of the auditor certificate, so that you can do that balancing exercise. But in practice, that's not something done unless requested or in the context of debt collection. And the auditor certificate as well, I know in practice that can be, a lot of auditors for certainly residential management companies aren't familiar with these certificates. They're not sure what's required. They will say, well, the expenditure for the year is in the accounts. Why do you need a separate certificate? And in practice, we would only look for it in the context of debt collection proceedings. We did have a case recently where we were worried we didn't have auditor certificates for a number of the years. There had been a change in auditors and the previous auditors weren't, cooperative in terms of giving the certificates, but the judge, accepted the audited accounts as a record of the expenditure incurred. So if you're going to court to collect collect service charges, what will you need to have in court? Now the counterpart lease, in a commercial case, you will need the counterpart lease, or you'll at least need a plain copy or a certified copy. If it's a residential unit, you've sued on foot of the statutory obligation to pay the service charges, then you don't have to have the counterpart lease. What you may be able to get is a template lease, and we've done this in certain cases, a template lease, and ideally a letter from the developer's solicitor saying they were all in the same format. Auditor's accounts for the relevant audited accounts, that should say for the relevant service charge years, service charge demands and statements, and the auditor certificates for the relevant service charge years. So that's separate to the accounts. That's a letter from the auditor saying, I certified that the expenditure for the following years was, and he or she lists the years and the expenditure. So just to talk about, I have, my apologies, I have an old version of the slides up on the screen, Neil, I've just realised, which, so it's not populated, so sorry about this. I'm just going to stop sharing just for a moment, sorry about this. And I'm conscious of time as well, I don't want to delay you.
Do you have the correct slides there, which is
I do, Neil. I'm sorry, I'm after opening.
You're fine. Don't worry at all. Don't worry at all.
Headings without the so I just, oh gosh, I'm trying to get into Zoom. Sorry to stop sharing.
Were the slides you sent me, were they the correct ones, or I have them here?
They should be. Yeah.
Okay.
Sorry now, everybody. I don't want to delay you. My apologies.
No, I'm just sharing the screen there if you want to.
Yeah. No, that's there. No.
Okay.
Sorry, Neil. That's
Oh no, you're fine.
Let's go into them here. Now. Oh. Here we go. Sorry now. I'm just going to share this. Share screen, sorry. Sorry now, my apologies. Hopefully that's
Now we can see that all right, so that's good.
Sorry. So just to move on, and I am conscious of time, I'll just to talk about service charges in just open the I don't think that's full screen, but anyway, so service charges in just to talk, I was obviously talking about residential. A lot of it is, you know, a lot of the same provisions will apply. But where you have a commercial only scheme, and it could be an office block, an industrial estate, or a shopping centre, and in that circumstance, you may have a management company providing the services, or you could have a landlord providing the services directly. Similar service charge provisions will apply, you know, regardless. But in a commercial setting, everything depends on the wording of the lease. The MUD Act does not apply unless it's a mixed use scheme. So hopefully the lease will have been set up, you know, correctly in the first instance, but sometimes not. And it can operate unfairly, you know, if it hasn't been properly drafted. But the same as in residential, the lease will determine services to be provided, how the service charge is calculated, and the entitlement to charge. In 2020, 2 years ago, the SCSI published a code of practice. It's a very detailed code. It's over 100 pages. And in the same year service charges in commercial leases. And in the same year, the Law Society issued guidance and template clauses. And in fact, the Law Society guidance refers to the SCSI code of practice. And the code of practice deals with, you know, how you know, good practice in terms of levying service charges. And it makes reference to the fact that you always go back, you know, to the lease. You have to charge out the service charge as per the lease. If it's a new lease, there can be substantial negotiation to ensure full recovery for the management company or landlord, and fairness for the tenant. But of course, if it's a new, if it's an existing scheme, you know, the ink is dry in terms of what's in the lease. And there can be a number, the service charge provisions in a commercial lease, they can be a lot more detailed than you'll see in a residential lease. So you may have certain carve outs, you know, so the tenant, say a tenant in a shopping centre, doesn't have to pay debt collection costs, doesn't have to pay construction costs. There can also be step-in rights, because if the management company or landlord isn't providing the services, a commercial tenant who probably had more negotiating power at the time the lease was being agreed may be able to serve notice on the management company that services aren't being provided, and if the breach continues or the non-provision continues, may be able to step in and do the work or provide the services themselves. There can be provisions in the lease that income from common areas such as a car park may be used to offset service charges. You won't see that in a residential setting. There are different methods of apportioning the service charge. It's usually based on the floor area, and certainly the Law Society template refers to the measuring code of the SCSI relative to the lettable areas in the development. Some leases will refer to rateable valuation. Some leases will refer to a fixed percentage, which is normally quite inflexible. But certainly, as I said, the Law Society template refers to the measuring code and the lettable areas. Again, distinct from residential, the landlord may be entitled to borrow. Residential management companies just simply have no ability to borrow. But under the commercial leases, often the landlord may be entitled to borrow and can charge out those costs, or can charge out costs to the tenant over a period of time with interest. And there usually are similar clauses to residential leases, the ones I was talking about your budget, everybody having to make an advanced payment and end of year statements. But the difference with commercial is that the tenant may have the right to challenge the statement, and there may be dispute resolution clauses within the lease, where it goes to, an independent arbitrator in the event a tenant isn't happy, and that isn't standard with residential. The remedy for a residential unit owner is probably the circuit court if they're not happy with either compliance with the MUD Act or with the lease, which is a relatively expensive remedy and not one everybody's going to run off to avail of. So just to cover just the last point there, can a lease be varied if the service charges, I have 2 more slides. Can a lease be varied if the service charge provisions don't work? Now, the first you have to look at the lease. Does the lease allow the service charge apportionment to be varied? And if it does, happy days. There might be a procedure to be followed in terms of, notifying people. And a management company or landlord will always have to act, generally it says reasonably and in the interest of good estate management. So the lease itself might allow the service charge apportionment to be changed. If it is to be changed, it's very important to have a record kept of the basis for the change and why it's being done. In a residential context or in a mixed use scheme, if the lease doesn't allow you to change the service charge provisions, then either the management company or indeed any of the owners could apply to court to vary the scheme documents, either due to an error, if there's a mistake, or on the basis that the apportionment isn't fair and equitable. Now, I have had cases where individual leases have been varied by agreement, and that's the third bullet point there. If the lease doesn't allow it, and if you're not going to go to the circuit court to change it because the MUD Act doesn't apply, it can be done by agreement of the parties. So I have had, a number of cases where there's a clear error in a lease, and it could be varied. Now, sometimes it's the service charge, sometimes it's the map. Quite often the maps aren't correct, but a lease can be varied, but only by agreement of the parties to it. And you cannot have a situation where a management company would agree to change one lease that would adversely affect other owners. So if you're going to change the service charge apportionment, you can only do it if you in a commercial setting, if you got every single person to agree, or in a residential, if you got every person to agree, or you had a circuit court order, and otherwise if the lease allowed it. So the last slide just to cover there is what remedies does an owner or tenant have in the event of non-provision of services. Now, if it's a commercial setting, the lease may give the tenant or lessee step-in rights. So they would notify the landlord, you're not, providing this service. If you don't provide it within 21 days, we're going to do it ourselves and we're going to deduct it from our service charges. And, there are some tenants, maybe, an anchor tenant in a shopping centre who would have very strong bargaining rights and may well have very strong step-in rights in their individual lease. In most cases where you don't have that, the only remedy that a tenant or a lessee has is an action to compel delivery of the services, and the lease doesn't allow them to withhold payment of the service charges. Not ideal, not what some clients want to hear, when they're asked, what can I do? The management company isn't fixing the roof, isn't cleaning the windows, well, you can sue them, but you still have to pay your service charges, and they're looking at you in disbelief. But that is quite often what the lease says. And of course, a management company will quite reasonably say, well, how can we provide services if we're not being paid? So you can have a Mexican kind of standoff. A commercial lease will often provide that the management company isn't, or the landlord isn't, liable for any loss unless notice has been given and the breach continues. So again, a commercial tenant may have more call on a management company or landlord in terms of losses that might arise. In a residential context, very unlikely that the lease will allow for that. It'll usually say the sole remedy is to compel provision of the service with no liability for any loss, even with notice. So the residential lessees will generally have a lot less, they'll have a much weaker enforcement rights than a commercial tenant, particularly one who has negotiated maybe strong stepping rights in the event of non-provision of services. So I'm conscious of time, and I hope I didn't rush there at the end, and apologies for the issue with the slides. I'll stop sharing them there.
Brilliant, Suzanne. Thank you so much. Really interesting there, and of course a lot of members on the call understand the difficulty or problems OMCs have with people who default on their obligation to pay the charges, particularly the smaller developments, of course. We have some questions in. I know we are tight in time, so I might just quickly throw them to you, if that's okay. Just one here we received, as a tenant renewing their lease and a rent review exits and progressed, can the tenant negotiate the service charge fee also with the rent review negotiations?
Unlikely. Normally the service charge provisions are fixed, but certainly if there was a break clause in the lease, it might be an opportunity to renegotiate the terms, but generally not. Okay.
Regarding commercial leases, when the landlord requests payment of service charge regarding the commercial lease, is the landlord legally obliged to provide a written explanation rather, or only a numerical breakdown of service charges?
Again, I suppose the answer is what does the lease say in terms of what the tenant is obliged to give. Normally they will be obliged to give a budget. That's in terms of the advanced payment. And then at the end of the year they would normally be entitled to a statement which should give more than figures. It should list the categories of expenditure, but you'd have to look at the lease. If it's not very well drafted, it may well not entitle the tenant to anything, but there's no statutory obligation like there is in the MUD Act.
Okay. Just another one here. In the event of a shortfall in the payment from an insurance policy for repairs to a common area, say from a fire or burst pipe damage, can the sinking fund be used to make up the difference?
The sinking fund can only be used for those 4 categories of expenditure, but it would be, it could be used for the improvement, I think, or refurbishment. So I think, that would fall under that. The shortfall from the insurance would fall under one of those categories. It's often a question, this isn't the question, but who pays the insurance excess? And that very much depends on the circumstances. And often in commercial leases, the tenant can be, it will say who's to pay the excess, and it will actually sometimes oblige the tenant to make up the shortfall in the event of an insurance claim. But generally in residential, the answer to that question would be yes, it is something that the sinking fund could be used for once it's refurbishment or improvement of the development.
Brilliant. Okay, so maybe just one more there, and just to make everyone aware that we can, Suzanne, if you're okay, maybe we might share the slides from today.
Oh yeah, that's fine. Yeah, I'll give you the correct version then.
Brilliant. Yeah, and any other guidance links any members would like, I can just pop my email there in the chat. So just the last question there from member: is there any minimum required percentage of members needed to agree any change to the lease?
Generally unanimous. If you wanted to make a change to the lease that was going to affect other owners, then you'd either have to get everyone to agree and everyone to sign a deed of variation, which is generally in practical terms impossible. So what I would usually say to management company clients is have a meeting, get an ordinary resolution as to whether people want this change, and then go off to the circuit court and get an order. Not the easiest of things, but that's the only way you're going to change the leases without every single person signing a deed of variation. But
Okay.
you kind of individual problems, sorry, Neil, just to make the very final last point, you could have an individual error in a lease, most typically because there's maybe just a typo or the map is wrong, and that can be changed, no problem, without everybody. You know, it doesn't affect anybody else.
Okay. Okay. Useful to know. Okay. Yeah, I think we're just a bit over time there, so we might call it. Really thanks to you, Suzanne, for giving your time here to present to us on this topic. And
The technical issues again.
yeah, no problem
Yeah.
at all. All righty. Listen, thank you everybody for joining in, and talk soon.
Thanks. Bye now.
All the best.